Talking today about just the basics of estate planning and going over some terminology and what you can really expect so that if you need to update your estate plan or need to get started for the first time, you really have the lingo and the tools necessary to be informed when you go into your estate planning meeting, either with your attorney or you want to talk about finances with your financial representatives. You will know what you need to ask. So basically, estate planning is really two different facets. It is the process of making decisions about who can exert power for you and what powers they can exert when they make decisions in the event of your incapacity during your lifetime. And we're talking about how your assets are distributed after you pass away. The most common documents you'll find, there are about 5. So we have the durable power of attorney for finances, the durable power of attorney for healthcare decisions. It's also called a patient advocate designation, or PAD, if you hear that terminology. People may have heard of the phrase living wills. Those aren't recognized by Michigan law, but they are recognized in Florida. Those are two slightly different documents. And since they don't belong in Michigan, we won't go over them today. Then we're getting into things that you use after death, and those are going to be your will and testament, a revocable living trust. You may have heard of the terms irrevocable trust. Those are, both trust kind of documents. And then a newer document called the funeral representative designation. And that allows you to pick who gets to make decisions for you for your funeral, and it allows you to express your wishes and desires for what you'd like to have happen to your body. So there are some additional documents that are kind of beyond the scope of, the basics that we're talking about today, but there are also going to be documents that you'll need to include in your specific plan if there are unique situations that relate to you individually. One of those would be a special needs trust. So if you have someone who is going to be a beneficiary and they have a disability and they rely on means tested benefits, this is going to be something that you're going to want to consider as adding into your estate plan, along with irrevocable life insurance trusts. These were very popular quite a few years ago, although we are seeing an increase in popularity now. And they are used to offset the federal estate tax by keeping a insurance policy outside of your personal name. So it's not owned by you, it's owned by the trust, and therefore it's not included in your estate tax. There are other more complicated trusts that you can use for spouses and you can use for charitable purposes, and that's really beyond the scope of what we're talking about today. But I love to get nerdy. I love to be a little wonky and get in the weeds. So if you ever want to talk about that in the future, I'm happy to do so. So let's start with power of attorney documents, because I think that those are probably the most crucial documents that you could have, because those are documents that you could actually benefit from during your lifetime. So really, when we talk about why these are so important, if you can't make decisions for yourself, your loved ones don't automatically have the right to make decisions on your behalf. So they can't necessarily access any of your financial accounts, and they can't talk to your healthcare professionals and make decisions for you without some prior consent. If you do not have these documents in place, you end up needing to go to the court and have a conservator or guardian appointed for you. And if you have a power of attorney document in place, you get to avoid the process of going to court and having to petition the court to get someone set up. And that is expensive and time consuming. Since we do that for a lot of clients, we definitely are familiar with that process. And, clients usually wish that someone had these documents in place. Now, again, these are helpful to avoid going to the court to get appointed, and you really get to have a lot of say in what you want for your financial power of attorney and your healthcare power of attorney, in terms of what decisions can people make, how much authority do you want to give them, who do you want to make your agent. So there are a lot of aspects to consider when you use these. Exactly here we have that they allow you to provide explicit instructions as to how you want your finances to be handled and your medical care if you can't make those decisions yourself. One of the things that is a common misconception is that these documents last after you pass away. That is not true. They only last until you pass away. At that time, they terminate. And then whoever is nominated as your personal representative in your will or your trustee in your trust would then be able to take over and start making decisions from there. So these are really limited to scope in your lifetime. Things that I'd want to point out just before we move on to the funeral designation. In your patient advocate designation, this is where you get to make some broad strokes decisions. These are decisions about how you want your medical decisions made, what scope of authority that would be. So do you want to be on life support if you are brain dead, or would you like someone to take you off that support? Do you want to have someone be able to revoke a DNR that you put into place? Do you want someone to be able to make decisions about organ donation? These are all important things that you need to consider and really think about who is going to be the right person to make those decisions for you. If you are thinking about someone who has medical knowledge, that's always a plus. Someone who's nearby in the event of emergency, that's a great thing. And I would also say someone who has the fortitude and will to take care of and exact the decisions that you make. It may not be their decision, but they would respect whatever you wanted. The other thing that I would say is that, especially when we're talking about finances, we can go very broad and very narrow in terms of what powers people are allowed to have. And I think that it's one of the things that we need to make sure that whenever we're talking about financial power of attorneys, that whoever you choose as your agent is trustworthy. My advice when you're picking someone to act as agent is, if you wouldn't feel comfortable handing over the keys to your bank account right now and know that this person will use it correctly, don't use them, because I don't want you to ever have a doubt as to the financial propriety of the person that you get appointed. So those are some things to kind of think about when you're just thinking about these documents and really starting to get a feel of what these documents can reflect. And, you know, we can really make sure that your wishes are known. The next one that is also similar to this planning technique is the funeral representative designation. And this allows you to select a person to be responsible for making decisions about your funeral. Michigan law prevails if you do not make a choice. Right now, the default priority would go to a surviving spouse. And if you don't have a surviving spouse, it would be up to the majority of your living children to make a decision. I have to say, one of the frustrating things about the law as it's written is that there is no mechanism to enforce it. So if there is a funeral parlor that doesn't really recognize the law, and I've had this happen before, where we've had the majority of children, but not all of the children, agree on what happens with the body, then the funeral parlor can say, hey, I'm not going to do that, get a court order. And that's frustrating to people. But what they will recognize is a funeral representative designation. So you get to pick the person. And in this document, you're also able to make wishes be known. So if you have plots that you've purchased somewhere, or if you know that you want a specific officiant or have a specific religious preference in terms of ceremony, this is a place where you're able to write that down. Now, it's not mandatory that the person who is the funeral representative make those decisions, but it is a strong suggestion, and it really gives everyone peace of mind to know that they're doing what you wanted after you pass away. So switching over to now assets. We talked a little bit about what happens to you, what happens to your body. Now we get to talk about what happens to your assets. So if you do not have any sort of trust, assets that are in your sole name pass according to the terms of your will. And that would be a probate asset. Essentially, what a probate asset is just an asset that needs the power of the court to intervene to transfer it from your name into the name of your beneficiary. Assets that name a beneficiary pass to the beneficiary automatically, regardless of the terms of the trust or will. So think of these as some of those financial accounts that you have with Nick and David. So these are going to be your life insurance policies, any sort of retirement accounts, any mutual accounts or brokerage accounts. These are things that you should talk about with your financial representatives, because they'll be able to help you complete these beneficiary designation forms for whatever financial institution that you work with. Assets that you hold jointly with rights of survivorship pass to the surviving owner, again, regardless of the terms of your will or trust. So let's say that you own a parcel of property with you and your brother, and you pass away. If it is with rights of survivorship, your brother's going to own that property, whether or not your will says that all of my property goes to my surviving spouse. So this happens a lot, particularly in real estate, but it also can happen with financial accounts. If you think about a brokerage account or a bank account, you can own those as joint with rights of survivorship. It's really nice for people who are married to hold accounts that way, because after the first spouse passes away, all that's required is the presentation of a death certificate and some forms from the financial institution, and you'll be able to have access to that money, and it'll be appropriately titled in the survivor's name. Last and not least, assets that are held in a trust pass to the beneficiaries that are named in the trust. So when we talk about probate avoidance, that's what we're talking about here. So as long as we have assets in the trust itself, we don't need to go to court in order to get those assets passed through to the people that you intend. Now we have the big question: what happens if you die without a will or trust? In this cartoon, I particularly love it. You know, James didn't leave a will, but he'll still be able to get you help determining which of you gets his inheritance. So whoever gets the long side of the wishbone. It doesn't quite work that way in Michigan. We get the state of Michigan plan. So basically, are you happy with what the legislature has chosen for you? If not, well, then you should probably make some documents. If you die without a will, it is called an intestate estate. And all that means is just an estate that doesn't have a will to direct where assets go. Assets can pass in ways that are contrary to your wishes, and there aren't really options for charitable gifts there. I have a lot of clients come in and say, but Dad told me he was going to leave me such and such property. If it's not in a will or if it's not in a trust, then I can't guarantee that that's going to be what happens. In this example, we have Sally Spartan died, and she didn't have an estate plan, and all she had was $100,000 in the bank in her sole name. She was survived by her 3 children, and one of those kids, Wally Wolverine, she didn't want him to receive anything, maybe because of his choice of college. We can't be positive. And she had hoped that $10,000 would go to her church and the remaining property would get split by her other 2 children. She told her children this many times. Unfortunately, that's not the way it works if you don't have a will. If you don't have that, the account is going to be divided equally among the 3 kids, regardless of her wishes, because that is the Michigan plan. That is the default that we go to. To give you an overview of what that Michigan plan looks like, it initially goes to a surviving spouse. It is interesting because if there's a surviving spouse and you don't have children, but your parents are alive, your parents could potentially get a certain percentage of the estate above a certain dollar threshold. And the same goes for if you do have living children, with or without that spouse. You can have the surviving spouse get the majority, and then they get to split the rest of it with those individuals. So it's a little bit of a funky system. It's not as intuitive as you might believe. So the will is going to be a document that takes effect after your death, and it only affects those assets held in your sole name. Again, if you have beneficiary designations, all of that property goes to the beneficiaries immediately. A will is nice if you have children, because it does allow you to name a guardian or conservator for your children in the event that one needs to be appointed. So that's a really good opportunity to start thinking about, if something happened to you, who would you want to make decisions for your children? The idea of a guardian and conservator: a guardian is for making decisions about the health and well-being of the person. A conservator is about the assets of a person. So you can actually have two different people in charge of, your child's rearing and your child's finances. You can do that. The person who you choose to administer your will is called a personal representative in Michigan. Sometimes people hear the word executor, and in Michigan, we just use the terminology personal representative. It's in the legislature and the text of the statute. Everything that you have that gets passed according to a will is subject to a probate estate, and you have to file that with the court. Probate, again, is the process by which your assets get titled from your name into the name of your heirs. And the probate process in Michigan is cumbersome, but not impossible. It lasts for a minimum of 5 months, according to statute, and you have to pay an inventory fee to the court for the assets that are getting passed by probate. You also have to pay a fee to open up the estate, and if your estate is over the small estate thresholds, then you also need to publish a notice to creditors and provide notice to any known creditors that exist that an estate has been opened for you. Then we go to the trust, which is it goes hand in hand with the will. We always want to make sure that when we are doing an estate plan, we have a will no matter what, because there's going to be a chance that you have an asset that you could not account for during your lifetime. Specifically, if you ended up in an accident and someone had a wrongful death claim, you would need to do that through your estate. Or it might be possible that there is an asset that you don't know about. Sometimes people have things in unclaimed property, and the way to get that property through is, again, through the estate mechanism. So we always like to have a will just in case. But the revocable living trust is basically an excellent option to provide management of your assets during your lifetime and at death. The trust controls any assets that's been transferred into it. So we can create this beautiful trust with all of the requests that you've asked for. We can fulfill all sorts of sub-trust requests. We can make it very interesting and complicated. But if you do not fund the trust with your assets during your lifetime, then there's no reason to have a trust, because the trust can't essentially do anything unless we had some sort of mechanism to get those assets into the trust. I like to think of it as a bowl. You have a fruit bowl on your counter. It's beautiful. It looks great, but it doesn't really serve a function until you put something in it. Now, the trust is administered by the trustee. So you get to select this person just like you would a personal representative. But because your trust can be in existence and operate during your lifetime and after your death, you actually can be the trustee of your own trust until you pass away. Another thing that we always like to consider that might be appropriate for some families is if there's a complicated family situation, or you don't really think that anyone is up to the task of doing all the work required by a trustee, you can always name a third-party financial institution to act as your trustee. There are several different banks that have trust departments, and they are devoted to just administering the trusts that come to them. And that may be a good plan if you have a family. Maybe it is a blended family from multiple marriages. Maybe it's just a large family. There are a lot of beneficiaries involved. Or it could be a situation where maybe it's not a large family at all. It's the exact opposite. You don't have children, and there's no person that you would just automatically assume is getting your assets or handling that transition after you pass away. That would be another time where you'd be able to use a third party. Assets in your trust are great because they are not subject to probate. So we don't have to open up a probate estate with the court. We don't need to file an inventory fee. We don't need to do any of that. But you do still have to provide notice to creditors. So if there are any creditors in existence, you don't get around that notice requirement just by having a trust, but you do get to avoid all of the other formalities of going to court. And if you have a larger amount of assets, sometimes that inventory fee can get kind of high. So it's nice to avoid that. One of the great things about trusts, and one of the reasons why we highly encourage them for some situations, is that it is a very flexible document. You can make changes whenever you want to, and it also provides a lot of flexibility and control after you pass away. So for instance, if you have minor children and you don't want them to get their money immediately when they turn 18, we can put in the trust that it can be held for them for their benefit until they reach whatever age you want. You know, let's say 25, they're out of college. Or it could be some sort of age and stage combination where we're talking about maybe after college, maybe when they're getting their first job, after they get married. We can really get creative in terms of those distributions. We also have the ability to get creative for disabled beneficiaries so that any sort of distribution to them wouldn't affect any means tested benefits. It's also great for non-traditional families and for spousal shares. So if you want your spouse to receive the benefit of your assets during your lifetime, but you don't want to give them outright to the spouse, knowing that she could turn around and give it to a future spouse if she got married again, or give it to her children and cut your children out. It would be something that would be great to do in a trust, because you could give the benefit of your assets to your spouse, and then after they pass away, it can go to your children. So there's a ton of flexibility there, and we can really get creative. Again, some of the advantages we've already talked about is getting really creative with our distribution planning. We get to avoid the probate court's involvement. We can provide ongoing trusts for a long time for children and other beneficiaries whose assets might need management and protection. If you have someone in your life who has a substance abuse problem, or maybe a gambling problem, or just you don't think handles money particularly well, having someone in charge of those financial decisions and having a second set of eyeballs before making a distribution might be good for you. We also have an ability to do some estate tax planning. Right now, the estate tax is so high that most of our clients don't have to worry about it, $11.7 million. So I'm going to say that 99.9% of the people don't need to have anything or worry about it at that level. But it does give the ability to defer or eliminate federal estate tax when you give all of a portion of your assets to a spouse. A spouse is considered an exempt party under the estate tax. So we can get to some creative tax planning in trusts as well. Sometimes I do get into a situation where I talk to people and we figure out that a trust really doesn't need to be for them. It is a great vehicle, but it's not appropriate for everyone. Every family has different unique circumstances and particularly different and unique assets. So it might not be in your best interest to kind of move forward with those. From the start, they are more expensive to prepare than just a simple will because it is a more complex document. We just have to go into more. It is longer and it takes more time for us to prepare. It also requires maintenance and upkeep during your lifetime, meaning that you are going to have to fund the trust. We're going to have to retitle some assets into the name of the trust or name the trust as beneficiary. So after your death, assets get put into the trust. And that's something that I get to rely on Nick and David a lot for, because they are great resources. If we do prepare a trust, they can help with that retitling and that beneficiary designation work from the get-go. but it's a matter of having to do it. It's an extra step that you wouldn't have to do otherwise if you had a will. The administration can sometimes become complicated depending on the amount and nature of assets. So for instance, if you don't want your children to get any distributions until they reach the age of 50, you have to keep in mind that a trustee needs to continue administering this trust every year until your children reach the age of 50, at which time, full distributions can get made. And that can be expensive because trustees are entitled to a reasonable fee for the work that they do. And they'll probably want to take one if they see that they are having to follow through and administer this trust over the next 15 years after you pass away. Estate planning is important for everyone across the board. I even recommend it getting at least power of attorney documents drawn up for children once they reach the age of 18, because it still allows you to make decisions for them if that's what they want. But non-traditional families happen to be a particular area where estate planning is even more imperative, because if you're looking to benefit someone who is not your legal heir, so think a stepchild, or maybe skipping right over a generation and going to grandchildren, or if you're looking to do charitable distributions, this is going to be important. Another thing that we see a lot is unmarried couples. We have a lot of lovely families who come into our office and they've opted not to get married for whatever reason. If you want your long-term partner to be able to have your assets after you pass away, you want to make sure that we create that legal right through a will or a trust, so that they are entitled to make decisions for you and that they're entitled to get your assets after you pass away. These are unique situations, but we see it more and more. I also would say in the case of a silver divorce or silver marriage, we're seeing a lot more later in life marriages and divorces. These changes in your marital status are really important to plan for, because we want to make sure those beneficiary designations get changed. And we want to make sure that someone is making decisions for you, and that's the person that you actually want it to be, and that there are no unintended consequences for a change in marital status after you pass away. So this is a bit long, and we don't necessarily have to go through this. I know that we have quite a bit of time here, but there are other ways that you can provide gifts that are not a will and they're not a trust. So one of the things that we're seeing, especially in terms of retirement plans, is naming a charitable beneficiary as a beneficiary on your retirement account. If you take any distributions out of your retirement account, they are taxable as income if they don't come from a Roth IRA. Again, Dave and Nick know more about this than I do, but if you are able to make those distributions to a charity directly, you avoid having to pay any income tax on those distributions. You can do this during your lifetimes with your RMDs, but you can also do it after you pass away. So sometimes that is a nice way to get specific assets directly to charities, and you get the benefit of not having any tax issues. Some of these planning methods are what we talked about earlier. We can do a gift annuity, a remainder annuity, charitable lead trusts, endowed funds. DAFs are seeing a huge explosion right now, which are donor advised funds, where you're allowed to set up a fund and direct how the management and the distribution to charities are done. You can create your private foundation if you want to, or otherwise you can do outright gifts. Something that is very fun for us is helping families long-term with gifting strategies. And that would include your annual gift exclusion. In case you don't know, every person has the ability to give any other person up to $15,000, and that is without having to declare it on any sort of gift tax return, and without having to have it count against you, your estate and gift tax exemption that we talked about. Right now, that's $11.7 million, but in the future, it could potentially reduce, and that could be problematic. So you get to really kind of play around with these gifting strategies. And if you start making $15,000 gifts over a long period of time, that adds up pretty quickly. I know that myself, I'm not in that position where I can just give others around me a $15,000 gift. So that doesn't necessarily work for everyone as a planning option, but it is available to some. And it's something that is worthwhile. And I recommend talking to your CPA or your attorney about it if you haven't already, and that's something that you'd like to consider. So there are a couple other unique issues related to estate planning, and we hear about them a lot. The one that I hear about most of all is Medicaid planning for long-term care and assisted living facilities. Medicaid has become an option for more and more people as medical needs become higher in our older age, because long-term care is just so expensive. I think we are up to an average of about $12,000 a month for services in a nursing home, and that I think is national. This is really expensive, and long-term care insurance policies have gotten quite expensive as well. So fewer people tend to have those. And when we are looking at getting people care that they need in a nursing home, Medicaid tends to be what we need to factor. However, people do still want to leave something, a little bit of legacy to their families. And people ask, well, how can I do Medicaid planning? Medicaid planning is an incredibly specific area of law that people make their specialty. In our firm, we have multiple attorneys who deal with Medicaid planning, and I will tell you that I am not one of them. I defer to my colleagues' expertise when a Medicaid planning question comes up, and I would always refer it to them. It is very uniquely situationally dependent. The facts of every single case matters and makes a difference in what the recommendations would be. So there's not necessarily any blanket recommendations. But if it's something that you're concerned about, or you're concerned about for a loved one, I definitely recommend talking to an attorney and seeing what we could do and how we might be able to help you plan for that in the future. Something that is also really interesting are gun trusts. They're useful for handguns that are required to be registered with the state of Michigan, and then weapons registered with the federal government under Title II of the NFA. This is really important because having it in the possession of another person could be tantamount to accidentally committing a felony. So gun trusts really help with the ownership of some of these firearms. And they're a unique asset that needs a little bit of unique planning. If you have some standard firearms that you would use for hunting, like rifles and things like that, that's a little bit easier, and those can transfer generally about the same as personal property. But when you get to handguns and other Title II weapons, it's really important to bring those up with your attorney, and so that we know to create a plan for how that's going to carry forward after you pass away. Finally, we've touched on this a little bit, but special needs trusts are incredibly important if you have a beneficiary who has some sort of disability, because getting an inheritance can unintentionally cause them harm, because it could take away the government benefits that they're receiving and relying on for their day-to-day care and support. So if you have an heir or a beneficiary who has special needs, it's a great idea to talk to an attorney about making sure that that individual is properly planned for. And it's also something that can come into play in Medicaid planning, because there are special exemptions and allowances for making gifts to someone with special needs. So this is a really important thing to keep in mind as you're looking forward and just trying to put together a plan that works best for your family and for your goals. Basically, just going to wrap this up before we get into some questions. And I'd really love to spend some time going through questions and following up on any areas of concern or, clarify anything that we touched on briefly today. But I wanted you to know that in order to make decisions about how your assets are going to be managed for your benefit, and then how your assets are going to be managed for your family's benefit after you pass away, is an incredibly important conversation to have. It might be a little bit awkward. No one likes talking about death, and no one likes to face the idea of their mortality, whether it come after a long, healthy life or at a terrible accident. However, making these documents and getting these plans in place allow you to have the peace of mind that you and your family are taken care of. One of the things that is really important too is talking to your family. There are a lot of people who choose not to give, evenly to kids, for example. Let's say that you have 3 kids and 2 of them live out of state, and one of them has been sticking around, has really been taking care of you. And in recognition of their long-term care and support, you want to give them a little bit more than their siblings. In those instances where you have unequal distributions, it's a good idea to have a conversation with your family and let them know of your decision ahead of time. While that might be awkward, it sure as heck is going to be a lot easier and expected for your family after you pass away, that they're not surprised. A lot of hurt can come from a plan or a lack of plan that is a surprise to the family. So I've seen that happen on the back end quite a bit, and open and honest communication is something that we really encourage. The last thing that I want to talk about before we open this up are some unique assets to consider. One of those is business assets. I work with a lot of small business owners who are planning for what to do with their business in their future. Is this something that's going to continue after their death? We need to put a succession plan in place if we are looking at a retirement situation. And just what happens in the event of a tragedy. If you got hit by a bus tomorrow, is your small business going to be able to run without you? Putting a plan together for your business assets is equally as important for you and for your employees as putting together an estate plan is for your family. You want to make sure that there are clear expectations and you know what's going to happen. That way, if something terrible did happen, your business will be able to either continue without you or wrap up in a way that would be meaningful and significant to you. I love working with people who own small businesses because that is just the heart and soul of the person. And there's so much work and effort that goes into growing that business that I want to make sure that it is treated with respect after you pass away. The other thing to think about in terms of special kinds of assets would be real estate. One of the things that happens very frequently in Michigan is hunting ground and cottages. I know we all know someone who has a cottage up north, and we all know and love special places in Michigan and want to make sure that our families would be able to use those in the future. There's a lot of planning that goes into cottages, especially if you want to make sure that the cottage is going to be around for generations to come. We are happy to work with you on that. And that is also an asset that really does need some special care and consideration, because it's likely that there's going to be a lot of control that you wanted to put into place so that you make sure that everyone has access to the cottage who you want to have access, that any expenses and maintenance and upkeep are planned for in advance, and that everyone who is engaged in that asset is really going to get full joy out of it. You don't want to have to tie someone to maintenance expenses if they live in California and will get to see this cottage maybe once a year, as opposed to someone who gets to go up every weekend. They're just thoughts and considerations that you might want to give. there are other assets that might have that unique situation tied to them. And if you know of any, or if you have other important legal documents like a judgment of divorce or a premarital agreement, those are also things to bring to your attorney's attention when you're meeting with them. Coming armed to the meeting with the facts is going to be very helpful for making a determination of what your legal obligations are and how those fit into your plan moving forward. So I guess Nick and David, I'd love to open it up to questions now.
I don't think we have any yet. If you have a question, there's a chat button near the bottom of the Zoom window screen. You can click on that and type your questions in for Molly.
If there's any document that you'd like to go into further detail about, I'd be happy to do that if you just want to type in the documents into the chat function as well.
So something that came to my mind, Molly, and that maybe we could elaborate on for just a second. You mentioned not funding people not funding a trust. Do you want to maybe elaborate just for a second on what it means to fund a trust?
Yes, I would love to. That is a great shorthand for a lot of legwork that can happen. When I say funding a trust, it means taking a look at the assets that you own and finding out what ways that we can get them to the trust so that they pass according to your desires. There are a couple different ways to do that. First is during your lifetime, you're able to actually name the trust as the owner of an asset. So you can change any bank account that you own and make it so that the trust is the actual owner. And you can do that through forms through your financial institution. The same thing would happen if you had any sort of brokerage account or other financial account. When we go to retirement benefits, we don't want the trust to own those because you actually have to own those individually for a lot of legal protections. And so because of those issues, we would want you to consider a beneficiary designation that would name the trust as your beneficiary. And you can put your spouse first and then name the trust if that's something you feel more comfortable with. But that way, after your death, that asset goes directly into your trust. So that is another great way to plan for getting those assets there so that they can be controlled by the trustee. The last thing that we like to do is retitle under certain legal situations. A great example of this would be through bonds or even real property. That actually requires that a title get transferred. And so we would need to record a deed with the Register of Deeds office, and that would allow you to transfer that asset either into the name of the trust right away or when you pass away. A lot of people in Michigan are familiar with the term ladybird deed. David and Nick, have you heard of this before?
Oh, yeah.
Yeah. So ladybird deeds are a really great vehicle for planning. It gets used in Medicaid planning, it gets used in estate planning, and it gets used in trust funding. And what it is a deed that says that you, person X, are transferring it to yourself during your lifetime with full ability to mortgage the property, to sell the property, to lease the property, to put an easement on the property, do everything that you can as you could right now. But after you pass away, if you haven't sold the property yet, then it would go to your named beneficiaries. And you can name the trust so that it gets funded into the trust after you pass away, or you can name beneficiaries directly, including things like children, grandchildren, charities, anyone that you would want to include as a beneficiary for that particular parcel of property. And then you're able to have that transfer immediately on your death by the recording of a death certificate with the Register of Deeds office. That is a really neat function. And it is something that we like to see in both trust funding and in estate planning, depending on what kind of documents we're drawing up for a person. And so there are a lot of different kinds of assets to consider when we're doing trust funding. And I would say if you have any questions about them, talking and working with your attorney, and also talking and working with David and Nick is a great way to help along the process of getting those beneficiary designations or retitling documents prepared.
So we've got a question, Molly, for a little more detail, if we can, on Medicaid planning, understanding it's a separate discipline, but maybe a little bit more on the instances where a trust might be a favorable way to protect assets in a medical situation, Medicaid situation.
Yeah, so there are a couple of different trusts, and I won't say that this is necessarily Medicaid planning as it would be just asset planning in general, but there are certain trusts that exist in Michigan called Domestic Asset Protection Trusts, or a DAPT. And those are kinds of trusts that you can fund during your lifetime, so long as you're not insolvent when you're funding the trust. And there are a lot of limitations on what you can do with the assets that you put into the trust and who you can have as a trustee. But it is a way to shelter potential assets from creditors in the event that something catastrophic happens in the future. These are normally reserved for people with higher net worth and for people with higher likelihood of having creditor issues or liability issues in the future. Think for any sort of profession where you have to carry malpractice insurance. Right. That's going to be the situation where we're potentially thinking about. And you also don't want this to be for a situation where you need those assets to live. Because if you fund those assets into the trust, they aren't necessarily available for you at any time. And you don't get to make the decisions over those assets. You relinquish all control to a different trustee that has complete discretion over when and how those assets get administered and put out to you. So go ahead, David.
And that's the difference between it being a revocable trust.
Mm-hmm. Versus an irrevocable trust. So once you put this in place, you can't necessarily change the terms of it. So if that's something that you want to consider, I would highly recommend talking to an attorney. And I hate giving this answer, but whether or not it's right for you, the answer is it depends, because it's very fact specific as to when these sorts of things would come into place. And it may not be necessarily the best tool for Medicaid planning for a variety of purposes. However, there are ways that you can plan for Medicaid, and those change based on everyone's circumstances. For instance, is there a surviving community spouse? What type of assets do people have? Is it an income producing asset? All of these questions need to get asked. So unfortunately, when we're talking about things like this, the answer is it depends, and no one likes getting that answer.
Right. We've got a couple other questions. Could you elaborate a little bit more on the purpose and uses of gun trusts?
Yes, I would love to. I haven't drafted one in a couple of years now, but they are really practical for transferring ownership or even just holding ownership, particularly of those Title II weapons. And the reason why is that those weapons generally require registration, and they require documentation as to who the owner of those weapons are. And if you are found to be in possession without that registration process, then it could accidentally become a felony. So for instance, if you don't keep it locked up in a safe that your spouse has no idea what the password is, the spouse knowing that password could turn into an accidental felony. And I don't want anyone to commit a felony, let alone accidentally. So the purpose of these trusts are really to hold those types of weapons both during your life and allow for other family members to possibly use them under supervision, and to manage and facilitate the transaction after death to make sure that whomever is going to be inheriting those assets meet the requirements under federal and Michigan law, so that it doesn't get transferred to them under circumstances that could make it illegal. So that's really the purpose of gun trusts, is just to make sure that we aren't committing any accidental crimes.
So we have another question on ILITs, on life insurance trusts. So could you discuss for a second the pros and cons and inner workings of life insurance policies offsetting estate taxes? The writer wondered how this might be used by high-profile critics of estate taxes, such as the Baldwin family.
Yeah, I think that ILITs are really interesting. They were used quite frequently in the late 80s and early 1990s, back when the estate exemption was only $600,000, if you can believe that. You know, if you have the estate tax being $600,000 was, of course, enacted in a time where $600,000 seemed to be quite a bit of money. But unfortunately, there was no cost of living adjustment that came through with that. So over the years, it became really untenable and was affecting quite a lot of middle income people. And so in those days, what would happen is that if you expected that there was going to be a potential liability for estate tax, what you can do is you can fund an ILIT, or an irrevocable lifetime insurance or life insurance trust. Then you would be able to have that trust own the policy on your life. And then you, as the grantor, can actually make a gift to that trust every single year for the cost of the premium. And then the trustee would then use that premium and pay or use that money to pay for the premium on the life insurance policy. However, because you are gifting that to the trust every year, you have to provide something that is called a crummy notice. And it's one of my favorite terms in all of legal speak. A crummy notice was actually named after a poor man who had the last name of Crummy. And it's a case that went before the IRS and basically said, as long as you provide notice to the beneficiaries of the trust and they elect not to take out their gift, which is a present gift, and they allowed it to sit in the trust, then it is okay for the trustee to use that. And then when the life insurance proceeds eventually come out of the trust, then that goes to them tax-free. And it's not considered a grantor trust. And a grantor trust simply means that the grantor has control over the assets in the trust. So if I made a revocable life insurance trust where I got to make decisions and constantly amend the documents and use the money for myself, that's a grantor trust. But the way that this becomes irrevocable and outside of your estate tax is that you lose all control of the money going into it that you gift. So basically, it is a simple thing that happens every year that you just deposit the money for the trustee. The trustee sends out the notice. No one takes out the gifts. And I mean, if they take out the gifts, they're silly because you can always remove them as a beneficiary in the future. And then the trustee is able to make that purchase, and the life insurance policy stays there. Because you've done all this work during your lifetime to make sure that you are not the owner of the policy, it can get paid out to the beneficiaries, and it isn't counted against your estate tax exemption, so you don't have to worry about that. And when the estate tax exemption was so low, a lot of people would do this so that there were liquid assets to pay the estate tax for their beneficiaries. This was particularly important for farmers who owned a lot of land and were asset rich, but liquidity poor, because otherwise you actually saw that families would start needing to divide up the farms, and actually you'll see some subdivisions in the middle of farmland, and you're like, where did this come from? And the answer is probably some poor family couldn't afford the estate tax, so they had to sell off the farm in order to be able to make that payment. So an ILIT is used for two purposes. One, to give your family some money outside of that estate tax exemption. and 2, to provide liquidity so that they can pay the estate tax in the event that there is any. That isn't so much a problem now with the exemption being so high. However, there is talk in the current administration that they would want to lower that amount. And just so everyone's clear that no matter what happens politically, the current amount that was set at 11.7 now with adjusted for inflation is going to sunset back down to a $5 million cap adjusted for inflation. The temporary increase was part of the Tax Cuts and Jobs Act of 2017, and it was always intended to sunset come 2026 unless there was any sort of action on Congress to continue it. So I just want to throw that out there. Again, 5 million adjusted for inflation, so it'll probably be a little bit closer to 6. It's still a lot of money, but it is possible that if you have worked hard and you end up passing away in the peak of your retirement years where you're just getting started, that you could have assets in that amount, and planning for them in the future is important, and an ILET might be a great way to help your family do that.
Yeah, particularly with the liquidity issues. I've been around long enough that we actually used to do this math, and it didn't do much to reduce the estate tax itself. It more was a better way to pay it than having to liquidate the barn and the tractors.
Mm-hmm. Yeah, especially for families with those big liquid assets. And it also was the case too if you owned a business, not just a farm, because those business assets can add up and count towards how much you own, but you're not going to sell off a part of the business because that could just destroy it in the future. So there are some circumstances where they still really make sense, and they are still a popular document to prepare now. It's just less so than it was when the estate exemption was so low. I mean, attorneys were preparing those all the time for people. You always had your individual trust and your ILET. Now we don't have to do that, luckily, but it could come a point in time where people want to discuss those more.
Any other questions out there?
Sorry, I stopped a little bit early and kind of rushed through all the material because I wanted to make sure we had some time for questions at the end. So it's coming up on 5 o'clock. So I think we did pretty good. Does anyone have anything else though? I'm happy to stay and chat and find out any other documents you'd like some more clarification on. Anything I can do for you.
I have a question for you, Molly.
Yeah.
I know we talked about this a little bit on our podcast, but I always am curious about how often you should be updating your documents. If you have them in place already, or maybe you had somebody do them 5-10 years ago, how often should you come in and see Molly to make sure that they're still correct?
That's a great question, Nick, and it's one that I appreciate you having the foresight to ask. This is something that we really recommend every year, just taking a quick perusal of your documents and making sure that there haven't been any big life changes for you. We're talking about deaths, marriages, births, divorces. These big life events are things that can impact what you maybe want to see or who you'd like to see as your beneficiaries or as your agents. So if you can do that about 1 to 2 years, I think that you're in a good position to just kind of review those to make sure that they meet with your desires. The other thing that I recommend is every 3 to 5 years, check in with an attorney, especially when we have revolving Congresses where we're going Democrat, Republican. There can be some changes to the law that you might want to make yourself aware of because it could change some of the things that you were planning. So for instance, if the estate tax were to change and were to drop to, let's say, $1 million, that's going to dramatically change how we approach estate planning as opposed to $11.7 million. We maybe have some different goals and planning opportunities for people. So that's a good benchmark, but it really is unique and specific to each person, which is why we really do encourage that regular check-in period. And I do want to say, Nick and Dave, that we have offered to the people here. If you reference the webinar today or the podcast that I did earlier last month, then you can come into our office and I am happy to give you the initial consultation, which is normal $285 free of charge. We'll wrap that into the cost of any estate planning documents that need to get updated or created. And you can do that and contact our firm anytime between now and June 1st. And if you reference either one of these and you move forward with an estate plan, I'm happy to wrap that cost in, because I know that sometimes you don't want to ask specific questions in a large group setting. And I want to make sure that each one of you has your specific questions and concerns answered and addressed.
That's fantastic. Thank you.
Thank you.
Yeah, I'm happy to do it. Your clients are important, and their concerns about their future plans are equally as important. And I want to make sure that we really can address those so that everyone has a chance and opportunity to ask questions if they'd like.
Thank you. Thank you.
Wonderful. Well, that's all I have. I don't see any other questions out there. So Dave, any last words? You want to wrap this up for us?
No, just thank you. It's always good to know we've got experts out there in these fields where Nick and I know just enough to be dangerous.
That's right.
I think we should title the webinar series that.
Just enough to be dangerous.
Yeah.
There you go.
That would be great. Thank you so much for having me. I really appreciate it.
Fantastic. Thanks,
everybody.
Appreciate all you do for us.
All right.
All right.
Enjoy your winter weather. It's snowing.
Yeah.
Funny here.
All right. We will talk to you all later. Thanks for joining.